So Robinson doesn't address that, and I think it's completely distinguishable. So Robinson was
Could you criminalize the status of homelessness?
Well, I don't think that homelessness is a status like drug addiction, and Robinson only stands for that.
Well, homelessness is a status. It's the status of not having a home.
I disagree with that, Justice Kagan, because it is so fluid. It's so different. People experiencing homelessness might be one day without shelter, the next day with. The federal definition contemplates various
At the
forms.
period with which, in the period where you don't have a home and you are homeless, is that a status? Could
No.
you criminalize that?
No, it's not. So Robinson talked about addiction like a disease.
You could criminalize just homelessness.
So I want to say first a couple of things. So I think that for the...
I mean, that's quite striking.
No, I don't.
That you think that you can criminalize just homelessness.
No, we're not saying that homelessness is a status, but most importantly, I think the Eighth Amendment is the wrong way to focus on this.
It's really a simple question. Can you criminalize homelessness? And you're suggesting, yes, you could.
No, we do not criminalize homelessness. I'm not saying...
Could you criminalize homelessness? Not tell me what you do, what you don't do. Could you?
So I think there would be due process problems and vagueness problems. I don't think there's an Eighth Amendment problem in the sense of Robinson, because that was a limited decision where the holding was solely about a disease of addiction. The court was very clear about distinguishing between addiction and possession or use. And so
you're right that it's a different status that was involved in Robinson. But Robinson made clear that there was a category of cases which were status offenses, which were different from conduct offenses. And when you started off here today, you said we're just criminalizing conduct. So to tell you the truth, I thought that this was going to be a question where you would say, no, of course we can't criminalize a status, but there's conduct here. And then I was going to say, what is the conduct here? But you didn't say that. You said you could criminalize even the status of homelessness. And that suggests to me that you're off on the wrong track in thinking about this issue.
So, Justice Kagan, I think the point where we are disagreeing here is really about whether the Eighth Amendment is the right framework for this discussion.
Well, the Eighth Amendment was the framework in Robinson. And so taking Robinson as a given, where Robinson said the Eighth Amendment protects you against status-based crimes. That's what the question is.
I don't think Robinson extends that far. I think Robinson itself was cabin, and I think the Justice Marshall's plurality in Powell goes into a discussion about this and how that was the right line.
What is the conduct here?
The conduct is camping, establishing a campsite, and it's the same as in the federal regulations that the National Park Service
So I didn't think
on.
that was the conduct. I thought that the only conduct here was sleeping outside with a blanket.
No, it is the conduct of establishing a campsite, which includes making a bed with bedding or other materials, and the federal law...
A campsite suggests something different to people. It suggests a tent. It suggests a conglomeration of people, tent camps, if you will. But your ordinance does not just prohibit that. Your ordinance prohibits a single person who is homeless, so does not have another place to sleep. That's a status. I don't have another place to sleep. A single person sleeping instead in public with a blanket. That's what I understand your statute to do. Is that not what your statute does?
The statute does not say anything about homelessness. It's a generally applicable law. It's very important that it applies to everyone.
Yeah, I got that, but it's a single person with a blanket. And you don't have to have a tent. You don't have to have a camp. It's a single person with a blanket.
And sleeping in conduct is considered, sleeping in public is considered conduct. And this court in Clark discussed that is conduct. Also, the federal regulations
sleeping is a biological necessity. It's sort of like breathing. I mean, you could say breathing is conduct too, but presumably you would not think that it's okay to criminalize breathing in public.
I would like to point to the federal regulations.
And for a homeless person who has no place to go, sleeping in public is kind of like breathing in public.
Well, 2 points. So first, even the federal regulations prohibit even sleeping. They don't even require any materials, including but not necessary under the federal regulations. So this is conduct that is understood by jurisdictions nationwide and even the federal government to be conduct that is prohibited. And so I want to make that point.
I'll tell you the truth, Ms. Kapoor. I think that this is a super hard policy problem for all municipalities. And if you were to come in here and you were to say, we need certain protections to keep our streets safe, and we can't have, people sleeping in any place that they want, and we can't have, tent cities cropping up. I mean, that would create one set of issues. But your ordinance goes way beyond that. Your ordinance says, as to a person, and I understand that you think it's generally applicable, but we only come up with this problem for a person who is homeless, who has the status of homelessness, who has no other place to sleep. And your statute says that person cannot take himself and himself only and, can't take a blanket and sleep someplace without it being a crime. And that's, well, it just seems like Robinson. It seems like you're criminalizing a status.
Well, it is not, and we agree with you that this is a very difficult policy question, and that's exactly why the Eighth Amendment...
Can you answer why? Why is it not? Justice Kagan has laid out one of the essential problems here, which is that you're making a distinction between status and conduct. Okay, we see that. And you keep saying this is conduct. Can you explain why?
The actus reus element, that's exactly what was missing in Robinson, and that's what we have here. And that's why that law was so unique. It's a very peculiar...
So it seems to me that Robinson actually hurts you and not helps you in the following sense. It seems both cruel and unusual to punish people for acts that constitute basic human needs. So here, unlike in Robinson, where, you had at least the sort of disease state, drugs and the like, and potentially culpable acts that relate to that disease state, here we're talking about sleeping that is universal, that is a basic function. And so I guess what I don't understand is, in this circumstance, why that particular state is being considered conduct for the purpose of punishment.
Well, I think that just illustrates the line drawing problems, because if you look at biological necessities and what a person needs to do, the Ninth Circuit's decisions in this area would allow all sorts of behavior.
Can I give you a hypothetical? Okay, so suppose the relevant ordinance prohibited eating on public property rather than sleeping or camping. We're talking about eating. And the city, for very, rational reasons, determined that when people eat outdoors, it creates problems with trash and rodents and the like, and so it bans eating in public places, and it punishes violators. Now, just as here, that seems generally fine, because most people have restaurants that they can go to, most people have houses that they can eat in, but some people don't have that option. They have to eat in public because they're unhoused and they can't afford to go to a restaurant. So is your argument same result? No Eighth Amendment problem, no problem with the city banning eating in public, even though that's a public function, even though that's a human necessity that everyone engages in, and really what's happening is you're only punishing certain people who can't afford to do it privately.
Well, it sounds like I take for a moment that you're not saying the law draws lines on any sort of irrational basis or any equal protection
No, the city has
issue.
A perfectly rational basis. When people eat in public, there's trash, there are rodents, there are problems. So the city says what we're going to do is we're going to say no eating in public. What I'm concerned about from your argument is the suggestion, you call it conduct, I appreciate that, but what we have happening in operation is that people who are able to afford doing this thing that's a basic human need privately are okay. They're not punished for it, but people who don't have any other option or opportunity except for to do it in public are the ones who are being targeted by this statute.
So, two responses. First, I think the Eighth Amendment is the wrong way to look at it. Someone might have a due process challenge to a law like that if there is a deeply entrenched liberty
But punishment
interest.
is happening. In my hypothetical, people are going to jail because they're eating in public. So why is the Eighth Amendment not implicated?
In that case, you would have a defense under Oregon law, for example, a necessity defense. And I want to get to that on the camping.
I'm sorry to interrupt,
Yes.
but on that point, I think we're having some debate about where to lodge the defense, whether it's under the Eighth Amendment or under the 14th Amendment. But do you concede that there are instances in which necessity defense, long recognized in common law, would apply to eating in public, sleeping in public, or other things like that?
Yes, I agree. And actually here, in the case of camping, Oregon law recognizes a necessity defense. So as a matter of state law and policy, and again, that goes to the difficult policy questions, that's why states are able to address the needs of what this issue raises. And so for something under Oregon state law, a person could raise that defense under the necessity defense. And then if that's not enough, if they believe that that's not broad enough somehow,
You're saying
they can
Oregon
argue
law
due process.
has that defense
Yes.
already built into it?
That's correct.
Thank you.
Let me ask you about Oregon law, because one sort of a threshold concern that I have about this case is I understand that Oregon has enacted a statute, a new statute, that seems to address this very issue. So I'm trying to understand why this is still a live case. As I read the new law, it essentially codifies Martin's rule that it says something about all regulations of this nature have to be objectively reasonable as to time, place, and manner with regards to people experiencing homelessness. So it seems like the state has already precluded grants passed from doing the sort of thing it's doing here. So why do we need to weigh in on that?
Well, no, it hasn't. So first, both sides agree that this case is not moot. There is no state law challenge in this case. But more importantly, that standard is very different from Martin, and there's never been a challenge.
What about
to our law.
constitutional avoidance? So fine, it's not moot, but wouldn't our principle be that we don't need to reach the constitutionality of this issue if there's another possible way of resolving it because the state has addressed it?
Well, not at all. So the state's law is very different, and we believe our laws satisfy it. But more importantly, the fact that the state is acting here is a good thing. We agree that states should be able to make policy and to weigh all of the competing concerns. And here, the need to reverse Martin is so critical because laws like ours, they really do serve an essential purpose. They protect the health and safety of everyone. It is not safe to live in encampments. It's unsanitary. We see what's happening. And there are the harms of the encampments themselves on those in them and outside. We know this. The federal government has cleared encampments here in the Capitol, in McPherson Square. So this is an urgent problem. And also there are downstream effects of all the other things that flow from it. But it is very important here to understand that the state laws and...
So is it your argument that the Eighth Amendment has nothing to say about how the city responds to such problems? I mean, suppose the city decided that it was going to execute homeless people. I mean, very extreme, I know, but it would solve the problems that you're talking about.
Well, that would be...
Do we have an Eighth Amendment issue in that circumstance?
Yes. I think
Why?
there you look at the punishment. That, again, here we're looking at the punishment, which is low-level
That would be
fine.
both cruel and unusual, wouldn't it?
I think it would be, yes. I think it absolutely...
Why not just yes to that?
Yes.
Counsel, can I ask you a question about the scope of your ordinance? So as Justice Kagan was pointing out, this criminalizes sleeping with a blanket at a minimum, right?
Yeah.
Correct? But as I understand it, after this decision, and maybe after Martin, before that, there was some question about whether it also criminalized having fires, campfires, tents. Can you talk a little bit about that and what the scope of it is? Does the Constitution then make it impossible for a city to limit the use of fires and encampments, tents, those kinds of temporary shelters?
It really does, because the rationale of Martin, the argument that it's a biological necessity to sleep outside, the respondents argue a blanket is necessary in Oregon. Some might argue a tent and a fire is necessary in North Dakota. The Eighth Amendment really doesn't give us any answers to what cities can and can't prohibit. It's really administratively impossible for cities on the ground as well as for courts to administer. So we're seeing...
I'm sorry. We have nothing to do with fires or tents. That was exempted under the district court's injunction, and the circuit court didn't require that. We're talking only about sleeping with a blanket. So let's narrow it to what it is. I agree there might be other cases in the Ninth Circuit that are not rational. And I don't mean to throw aspersions at those holdings, but some of them are not permitting time, place restrictions. Let's go beyond that. Let's go here. Here you're not precluded from prohibiting fires. You're not precluded from prohibiting tents. What's at issue is, are you prohibited from having someone wear a blanket anywhere in the city? Your intent was to remove, stated by your mayor, intent is to remove every homeless person and give them no public space to sit down with a blanket or lay down with a blanket and fall asleep.
That's not the intent of the law, and I would like to address that point because the other side...
Why don't you answer the basic question?
Yes. So
it's not about fires, it's not about tents, it's about not being a time and place restriction, about eliminating all choices.
So we think that it is harmful for people to be living in public spaces, on streets and in parks, whatever bedding materials, when humans are living in those conditions. We think that that's not compassionate, and that...
Oh, it's not, but neither is providing them with nothing. Well, to alleviate that situation.
This is a difficult policy question, Justice Sotomayor. It is.
Where do we put them if every city, every village, every town lacks compassion and passes a law identical to this? Where are they supposed to sleep? Are they supposed to kill themselves not sleeping?
So this is a necessity defense, as I mentioned, under Oregon law is available. States are able to address these concerns. This is a complicated policy question. We believe that the Eighth Amendment analysis, to go back to it, focuses on the low-level...
What's so complicated about letting someone somewhere sleep with a blanket in the outside if they have nowhere to sleep? The laws against defecation, the laws against keeping things unsanitary around yourself, those have all been upheld. The only thing this injunction does is say you can't stop someone from sleeping in a public place without a blanket.
Why don't you answer, and then we'll move on to the next round. And you can be thinking about an answer to Justice Sotomayor while we move into a different stage of the argument. Is being a bank robber a status?
No, I would say that a law, well, if your question is asking would it be permissible to punish being a bank robber, I think that would have vagueness problems probably.
Would it be someone who robbed a bank? That doesn't sound very...
Well, I don't think that it is a status in the sense of Robinson, which, again, I want to just focus on what we think Robinson stands for, and it's only its narrow holding about addiction. And there it was the status of being an addict without any mens rea. So a law like that, without any actus reus, a law like that is problematic without an actus reus. I think it would probably have vagueness problems, due process problems. However, the Eighth Amendment, this entire exercise under Robinson, is the only time this court has ever evaluated the substantive criminal law, and it raises all of these line-drawing problems. And the fact that I'm not here to defend Robinson as a matter of first principles, we don't agree with it. We think it was wrongly decided. We're just saying that it is so far removed, that our laws are so far removed from what was at issue in Robinson that it just isn't implicated here.
So if someone is homeless for a week and then finds available shelter, is that person homeless when he's in the shelter?
Under federal law, the HUD regulations, he is actually considered homeless. That shows the fluidity and the different ways.
Putting the HUD regulations to one side, can someone who is sleeping in a shelter be considered homeless?
Some would say yes, that someone...
What would you say?
I would say that at that point he is sheltered and homeless. I think that is...
Let me make it easier. What if he buys a home or finds a home or is given a home? Is he homeless at that point?
He is not. So for what's at issue in this case...
So you think the status of homelessness can change from one time to another?
Yes, I do. I think it's very fluid.
Is that consistent with the definition of status in Robinson?
No. So Robinson treated addiction as a disease and as something that... And many believe that addiction is something that someone has with them forever, and it's a struggle. So that is a very different situation. And here, if someone has shelter, let's say they were offered shelter yesterday and they refused it, and then today, when someone comes around and tells them that they're not permitted to camp, are they involuntarily there if they refused shelter yesterday? That's the question the Eighth Amendment does not answer. This is very complex. What if there is a bed available in the Gospel Rescue Mission, but like Ms. Johnson, a person doesn't wish to leave their pet? Her Rottweiler's not permitted there. So that is a difficult question for a person and a difficult policy question. But the person's status, yes.
Thank you. Justice Thomas?
Robinson actually included a crime of, as I read it, either to use narcotics or to be addicted to the use of narcotics. And the court was concerned about the status of being addicted to the use. Is there a crime here for being homeless?
No, there is not.
Justice Alito?
Robinson presents a very difficult conceptual question. Do you think that someone who is a drug addict is absolutely incapable that all people who are drug addicts are absolutely incapable of refraining from using drugs?
I think that for some that may be true, and for some perhaps they can abstain, but that's a question of free will and agency that's true of every law and what conduct we choose to regulate. That's
all right. Then compare that with a person who absolutely has no place to sleep in a particular jurisdiction. Does that person have any alternative other than sleeping outside?
So I think we'd have to ask all of the questions I mentioned earlier about what alternatives they might have had yesterday.
No, they have none. They have absolutely none. There's not a single place where they can sleep.
If that's true, then that may be the case. And in that case, at least in Oregon, they would have a defense of necessity.
Hello, traveler.
So the point is that the connection between drug addiction and drug usage is more tenuous than the connection between absolute homelessness and sleeping outside.
Well, I think in Robinson, again, the court did draw that line, but here the respondents are saying that the two are really the same, that camping outside, sleeping outside, and being homeless are two sides of the same coin. We think that that's wrong. It's collapsing the status that they claim into the conduct. So we think the conduct here is very clear because it applies generally to everyone. The law does not say on its face it is a crime to be homeless. I just want to make that very clear. Thank you.
Justice Sotomayor?
It was the brief of criminal law and punishment scholars that I was referencing earlier. I want to go back to Justice Thomas's beginning question. As I understood it, the Ninth Circuit never reached the excessive fines question presented by this case, correct?
That's correct.
So that's still open, and you didn't seek cert on that issue?
That's correct.
Assuming that there is no standing, I understand one of the appellees died. The one who was camping outside died during the pendency of this appeal. And there are two other named plaintiffs. I know they have fines on them. I'm not sure that either of them has any criminal crimes charged against them. Where does that put this appeal? Where does that put this case?
Sure. Well,
should we be vacating and remanding to see if there is a live plaintiff, a named plaintiff who is still suffering injury?
No. So here, the sleeping ordinance, which is the one that Ms. Blake challenged, that is no longer in the case. That ordinance limited only sleeping in certain rights of way and sidewalks in the city, and it was a different law, and that's not at issue here. So sleeping is not at issue. It's about the camping ordinance. And we very much have a live case because we are under the Ninth Circuit's injunction, and the named plaintiffs
The question is, could it give an injunction? Are
was
these
just telling you one of
well, I guess if they're not permitted to park.
is busy checking.
That's
So
correct.
it's not the camping, it's the parking, isn't it?
Well, in the camping, so we intend to rely on these laws. We want to be able to rely on these laws. They're very important. And
just focus on my question.
Yes.
Both these people sleep in cars. Both of them sleep in cars outside of the town. So they're not seeking camping permission. Is your city not provide for overnight parking in any location at night except in private homes?
Camping in a vehicle is included in the camping ordinance.
Well, that's going into a camp. How do you define camp?
Again, it is a place where someone has laid
So
down
if they
bedding
go
or
into,
has...
if there's a line of cars and they want to, and the cars can stay overnight,
So
they want to park in one of those spaces. If they fall asleep in the car, they're guilty of violating the camping law?
no, Justice Sotomayor, Ms. Johnson parks her car oftentimes at a friend's, so she is not violating the law at those times. So
Just answer my
parking
question.
everywhere is not prohibited in certain areas,
Is
private
sleeping
areas.
in your car prohibited?
If you are sleeping in your car in a park where you're not allowed to park
Have
overnight,
any
then
of
yes.
them indicated intent to sleep in a park, or have they just said they want to park somewhere in the city? And can they park somewhere in the city and sleep?
Yes, they have said that they have the intent to continue their conduct and that they will be therefore subject to the city's laws. And
I don't
subject
understand
to...
that answer. Okay.
Justice Kagan?
You've referred a couple of times to the necessity defense, so could you tell me how that would work?
Yes, so there, under Oregon law, if a person says that it's effectively the lesser of two evils, if they say I had no alternative, no legal alternative other than what I did here that broke the law, then I had no choice, and I therefore had to break the law, and it was in some sense involuntary, to use a term that many have been discussing. So there, it would be very narrow. It is a very narrow defense, so it would be in that moment.
So suppose that there is a person who is homeless and there are no shelter beds available and the person has no place to go and the person, of course, has to sleep. And the person, it's cold outside, the person has a blanket. So that's the minimum conduct that the law prohibits. So the person sleeps outside with a blanket, and the police officer comes, but the person says, well, I had no place else to go. Would the city continue to push for some kind of penalty?
Well, if a person received a citation, so if they did, then they would have a defense of necessity. It's asserted as a defense. So what the other side is
Well,
trying...
it's asserted as a defense.
Yes.
I mean, so you're not willing to say, no, we're going to tell all our police officers that they shouldn't give a citation in that circumstance. We're going to give a citation and then we'll see how the courts deal with it, is all you're going to tell me.
Officers always have discretion, and we know that they exercise it, and it's hard to know...
The question is not an individual officers' discretion. Individual officers are in a tough situation here.
They are.
The question is, what is the city going to tell individual officers? So what is the city going to tell individual officers about a case of the kind that I said? Are you going to tell individual officers, issue the citation and we'll see if the person knows enough to make a necessity defense and we'll see what the court does about that? Or are you going to say, there are some things that just ought not to be the subject of civil or criminal infractions?
So the city, in its policy, at the joint appendix, page 158, for example, talks about what officers are supposed to do. They're supposed to put people in touch with services first, to contact if there is available help for them. These laws are absolutely a tool for getting people the services that they need. Many people need that intervention.
Well, you're not giving me a real answer
Yes.
to the question of, is the city telling officers that they should give citations in that circumstance?
No, it is. If somebody, again, it is a matter of discretion.
Is there anything you can point? It's a matter of discretion.
Yes.
There's nothing you can point to that the city says, we have a necessity defense. What we're telling officers to do is to, act consistently with that defense, so that if it is truly a matter of need, that you are sleeping on the street alone with a blanket, no, the officer should not cite the person.
There's nothing in the record here that shows officers were told about a necessity defense and that what it would or would not preclude. That would be an individualized question after the fact if someone received a citation. And if they thought that that wasn't enough, the proper framework would be this court's framework in Kaler, where we would look at the asserted defense, their insanity of some form, and here it would be necessity, and we would ask whether it is so deeply rooted in our history and something that has to be imposed in this way on the states.
Thank you.
Thank you.
Justice Gorsuch?
I suppose someone could also initiate a class action of the sort that happened here if you were not allowing the necessity defense to operate and seek to have it enforced, couldn't they?
Potentially.
Yeah, thank you.
Justice Kavanaugh?
You've said several times that it's a difficult policy question, a complicated policy question. I think everyone would agree with that. How does this law help deal with complicated policy issues?
One of the most difficult challenges is getting people the help that they need, and laws like this allow cities to intervene, and they are an important tool in helping incentivize people to accept shelter. So Ms. Johnson, for example, has said in her deposition, it's in the joint appendix, that she does not wish to stay at the Gospel Rescue Mission. One of the reasons is because of her dog. She also had other reasons. She doesn't like being around people and so forth. People have all sorts of circumstances. It's very complex, and the individual
How does it help if
decisions.
they're not help? How does it help the rule here, the law here? How does it help if there are not enough beds for the number of homeless people in the jurisdiction?
So for Ms. Johnson, she sometimes stays with a friend. So
How
there are
about
other.
more generally, though?
Yes.
I guess if there's a mismatch between the number of beds available in shelters, even including Gospel Rescue, and the number of homeless people, there are going to be a certain number of people who there's nowhere to go.
That is a difficult policy question, and
How does this law
Yes.
help with that policy?
So it encourages people to accept alternatives when they come up so that fewer people end up camping. It also, there is harm in simply camping. Whatever materials people are using when they are living in public spaces without plumbing and infrastructure, there's harm to the whole city and to the whole community as well as to them. We know that encampments and these conditions also breed crime and very dangerous conditions. So the city has an interest in protecting everyone.
Do you think the constitutional rule should be different when the number of beds available in the jurisdiction exceeds the number of homeless people versus the number of homeless people exceeds the number of beds available in shelters?
No, that's what we've seen in the Ninth Circuit. We've seen that is unworkable. There is no way to count what beds are available and who is perhaps willing to take one and who would consider it adequate, then the question becomes, are those beds adequate? So here, gospel rescue mission.
That's a separate issue, I agree.
It is.
And it can be a challenging issue, I suppose. I know. As well. Let me ask one last question, which is how does the necessity defense differ from the constitutional rule? You touched on this, but I just want to get a succinct answer to that. The state law necessity defense differ from the constitutional rule.
You would weigh the harm from the individual's conduct in violating the law. So if someone were camping near a school or near or doing something or engaged in some behavior that was particularly harmful, and they had another place where they could camp, that would be maybe a factor that you would raise in the necessity situation. It's narrower. So in a case of the Oregon cases include people who are growing marijuana for medical reasons but without a license, and so the necessity defense was not accepted in that case because they could have obtained a license. So if a person had a friend to go to, had a bed available at the Gospel Rescue Mission, they would be expected to take it under the necessity defense. I think that's how it would play out.
I actually have one last question. When you get out of jail, if you end up, what's going to happen then? You still don't have a bed available. So how does this help?
So I do want to make a point about that, about the criminal aspect. The trespass law here is only triggered after several civil citations.
Right. No.
And at that
run
point,
through that cycle and you end up in jail for 30 days. Then you get out. I mean, you're not going to be any better off than you were before in finding a bed if there aren't, going to my earlier question, if there aren't beds available in the jurisdiction, unless you're removed from the jurisdiction or you decide to leave somehow.
No, there are services available, and the jurisdiction can put you in touch with services and programs to help you in those circumstances. And for many people, that is a point where they're able to get into treatment. So that intervention actually saves lives.
Thank you. Justice Barrett?
So let me follow up on that. So you're saying there are services available, there's treatment available, so people would ultimately move off the street? Is that what you're saying? Because I think part of the premise of all of this, right, is that there are not enough beds for homeless people to occupy. And so there will be a mismatch, and there are going to be some people who can't be cared for. Are you saying that if your law is enforced, there is a way for everyone to be cared for?
No, I'm saying that's a policy question that is quite difficult. But these laws are an important part of the puzzle. They're not the only solution, and we don't believe that they are. But we think they're an important tool. And without them, we've seen what's happened on our streets. We've seen that people are dying in encampments. We've seen that cities are being forced to cede all of their public spaces. So that ultimate question is for the legislature and policymakers to figure out what the right solution, what the right mix of policies is. But the wrong answer is to do what the Ninth Circuit did here and to constitute.
Let me just interrupt you there. You're right. It's a very, very difficult policy question. And I asked you before about whether this was just about blankets or whether it went into having fires or urinating and defecating outdoors and that sort of thing. And Justice Sotomayor pointed out that this particular injunction did carve out those things and was just talking about sleep. But, other cases have been litigated in the Ninth Circuit that have gone beyond that, and because the line is things that are involuntary, that are human needs, it can extend. It's difficult to draw the line. And whatever we decide here about this case is about the line. So can you describe for me some of the things that are difficult to figure out about the line? They're sleeping with blankets. What else?
Public urination and defecation, that is a serious problem. Those are parts of biological necessities of being human. A court in Sacramento addressed that, and the Ninth Circuit's opinions debated whether its rule would actually reach those things. I think any rule that we are wondering about and debating whether it would go that far, I think that is a sign that it is not a workable rule. The slippery slope here is very real. It's not just for camping and conduct that might be a biological necessity, putting aside tents and fires in cold climates. What other things would be allowed? All of the things that a human needs to survive, for example, potentially come into focus under the Ninth Circuit's rule, but also in other areas. Someone could say that my drug use or possession is the other side of the coin because I'm an addict, or because a person who violates other laws could say that I had a compulsion to do those things that I couldn't control. And the plurality opinion in Powell Powell addressed that very thing and why it's so important to draw the line there. And when conduct is involved, and once the court gets into deciding which conduct may be excused under the Eighth Amendment, it is so far afield of what the Eighth Amendment was ever understood to address.
Okay, speaking of status and conduct, you've argued that Robinson was wrong and we don't need to overrule it, and I agree. I don't think we should overrule Robinson. You've also been kind of resisting the status. You've been resisting characterizing anything other than the drug addiction that was at issue in Robinson as status. So what if the law said it is unlawful and punishable by 30 days in prison to have the status of homelessness? Just go with me. Just assume that the law defines homelessness as a status and it is a status. Would Robinson say that that law is unconstitutional under the Eighth Amendment? Would you concede that?
And you're saying that that is a status?
Yes, the law defines it as a status, and it's a status.
Well, yes, and I think it looks a lot like Robinson under that hypothetical, but of course we disagree that it is.
I understand you disagree, but you are accepting that Robinson draws a distinction between status and conduct, and you're just fighting about the definition of a status?
It draws the line where a law has no actus reus, so I think that's the easiest line. I don't defend the line under the Eighth Amendment because I don't think actually that I know the court didn't rely on any Eighth Amendment principles or.
But the hypothetical I just gave you had no actus reus either. The status of homelessness. I mean, it could be, 4 o'clock in the afternoon and the person is just standing outside the bus stop. Do you agree that if the law prohibited that, made that a crime, that under Robinson, whether Robinson was right or wrong, that under Robinson that would be a violation of the Eighth Amendment?
Well, I think the better framework is due process.
I understand that. Under Robinson, do you agree that that would be wrong?
Yes.
Okay. Thank you.
Justice Jackson?
So, picking up where Justice Barrett left off, you say that the ordinance here pertains to conduct and not to status, and I'm just trying to figure that out. I'm not so sure for this reason. It's because all humans engage in the act in question, sleeping. And yet, the statute operates, or the ordinance operates, to penalize only certain individuals, those who have no choice but to do that act in public. So it appears, I think, not to be the act that the state or the city in this case finds criminally culpable. It's instead the act as engaged in by certain people, by people who cannot afford housing and have nowhere else to go. So why is that the wrong way to think about it? And if that is the right way to think about it, why isn't that a status crime in the way that Robinson contemplates?
It's not, because we can look at the law and it has a conduct element. The conduct is establishing a place, a campsite. And that is something that a person who has a home
But you've just defined away the basic actus reus, right? The actus reus is sleeping outside, I guess outside to the extent you put outside in it, but that's the problem I'm talking about. The actus reus is the sleeping, right? That's not a criminally culpable kind of activity. That's what I think might distinguish it from Robinson and make it worse for you in a way. Because in Robinson, at least, to the extent someone had a disease, and the question was, well, are they engaging in otherwise criminally culpable conduct, buying and selling drugs, taking drugs? We look at that kind of category of things. Here, the actus reus is sleeping. Human. Universal. The city adds, okay, but you can't sleep outside. And I guess what I'm trying to understand is, to the extent that that only happens with respect to a certain category of people who have no other place to go, why isn't that really just punishing the status of being someone who doesn't have any place to go?
It doesn't apply only to those people. The respondents here are trying to exempt a whole category of people. So what you look at there is the conduct of camping.
That is worse.
Under federal law and in this court's decision in Clark, it was understood that that is conduct. It is just like trespass, where if you are found in a place, if you enter with permission, but then you remain there without permission under Quarles.
But it's not just like trespass, because presumably you have other places to go. So let me just ask you this other question. What is your understanding of the Martin rule? Because I thought it was premised on the circumstance in which someone had nowhere else to go and they needed to sleep and they needed to be there, but you seem to suggest that necessity is not sort of baked into what Martin was doing.
Martin speaks in terms of someone who is involuntarily homeless, and that raises all of those policy questions that we've been discussing about.
But assume they exist. Involuntarily homeless means the person has nowhere else to sleep.
Yes, that is the necessity defense is available, and what respondents are asking to do is to constitutionalize that very defense under the Eighth Amendment. So as I said earlier, it could be, the argument could be made, it would be a very high bar under due process, but that is the sort of argument that we would expect one to make under a due process framework under this court's Kaler decision.
Thank you, counsel. Mr. Kneedler?
Mr. Chief Justice, and may it please the court. In Robinson, this court held that the government cannot criminalize status, and respondent has conceded here today that the city cannot criminalize the status of being homeless. Our narrow submission in this case, lawful for a person to reside in the jurisdiction if he has that status. That is what the ordinances here do. As applied to someone who has nowhere else to sleep, which is an essential human function, the ordinances are the equivalent of making it a crime to be homeless while living in Grants Pass. Although we think the Ninth Circuit was right to recognize that the core principle of Robinson is implicated in this case, the court was wrong to award broad injunctive relief in the circumstances and manner in which it did. The Robinson principle requires an individualized determination, and the Ninth Circuit's failure to require such a determination and its issuance of much broader injunctive relief has led to the problems at issue that the petitioner and its amici have raised, not the core principle of Robinson. And therefore, we urge the court to adhere to the core principle of Robinson, but to emphasize that cities have flexibility to implement these, and in particular, time, place, and manner restrictions on where someone can sleep are entirely valid if they are reasonable. And indeed, the state law that Justice Jackson referred to establishes a state policy that time, manner, and place restrictions are the way to go if they are reasonable. I welcome the court's questions.
Mr. Kneedler, wouldn't you have a better argument if Robinson involved someone being arrested for using drugs, but then the court said that you were in effect arresting him for the status of a drug user because he had no choice but to use drugs because he's an addict?
No, our position is not that the conduct, as in Robinson, the drug addict can't stop from using drugs. That is not our position. That's a question of personal culpability on the basis of what.
So what's the difference between that and camping out? What you're saying here seems as though you're saying, well, there's no other choice, so you have to camp out. Therefore, you're really arresting this person for the status of homelessness.
Yes, but not because of an involuntary compulsion sense. I think, as Justice Alito pointed out, the nexus here is actually closer than in the addiction situation, because sleeping outside is essentially the mirror image or the other side of the coin, or the definition of the status of homelessness.
Mr. Kneedler, I agree that the distinction between status and conduct is a slippery one, and that they're often closely related. And in Robinson, though, the court said you cannot make the status of being a drug addict a crime, but you can criminalize the conduct, even if it is involuntary and compulsive. And Powell reaffirmed that line very strongly, at least the plurality opinion did, and said we're not going to go further. And I wonder whether the government is asking us to take that step that Powell counseled against by saying that it is status because effectively status. And this is throughout your brief. You use the word effective or essentially or tantamount to, those kinds of words. And so I just wanted to get your response to that concern.
No, we are not asking the court to take the step that it declined to take in Powell, which had to do with personal responsibility, the sort of issues that were involved.
And okay, if you're not asking us to do that, then I guess I just want to circle back to what Justice Thomas was getting at, which is surely the government wants to continue to enforce the drug laws and all kinds of other laws that people could make an argument that I had an involuntary need to do, a necessity defense to. You don't want us to wipe out all of those laws.
Sir, absolutely not. But what is different here is that the conduct that was suggested in Powell would have been based on the person's own separate antisocial conduct.
Well, Justice White made clear that some people are going to be forced to drink in public because they don't have a home. He made this very point.
No, we don't. But the point here is the government that is prohibiting the alternative. It's not the individual's inability to control his own conduct. The government, because of other circumstances, the lack of money, the lack of a friend to stay with, the lack of shelter space, there is no place. We take as a given in our position that there is no other place for the person to sleep.
I think wouldn't a drug addict though make the exact same argument? I had no other choice.
But that the other choice would be a matter of personal.
No, say the record says. But the record says there is no other choice. I had to do it.
Well, I do think that in engaging in conduct that is unrelated to. Let me take that back. The sleeping outside when you have no other place to go is the definition of homelessness.
Mr. Needler, isn't the response also that those two things are different? I mean, you're sort of saying it's about individual culpability, but it's not as though everyone engages in drug use, right? Certain people do, and maybe they have addiction, and maybe you can't punish them because of the addiction, but you can still punish them as criminally culpable for engaging in the act. It seems to me we are in a totally different category when you're talking about acts that everybody participates in, that no one thinks in and of themselves are criminally culpable. And yet somehow this statute is reaching out to punish certain people who engage in that universal human basic need. That seems to me to be the distinction in these situations.
That is a critical distinction, and not only is it something that everybody engages in, but it's something that everybody has to engage in to be alive. So if you can't sleep, you can't live. And therefore, by prohibiting sleeping, the city is basically saying you cannot live in Grants Pass. It's the equivalent of banishment, which is something that is unknown to the way.
Mr. Needler, wasn't Grant Pass's first attempt policy choice to put homeless people on buses so they would leave the city? And I understood that to be the history of Grant Pass. Police officers would buy them a bus ticket, send them out of the city, but that didn't work because people came back because it had been their home, correct?
They came back.
They came back.
They might have been.
So then they passed this law, and didn't the city council president say, our intent is to make it so uncomfortable here that they'll move down the road, meaning out of town, correct?
That statement was made at a public meeting of the city council.
All right. So let's assume what you're saying or accepting, that do you happen to know, or maybe I hope one of you knows, how many beds there are in Grant Pass, shelter beds?
I believe the only shelter beds, at least at the time the record in this case was compiled, was at the Gospel Mission. Has been at times a detox place. There's been a warming center that has been maintained, but in terms of shelter beds.
What we're talking about
Yes, and I think
disproportionate.
it's approximately 100. They're
Yeah. I thought it was much less than that.
Yes.
All right. So we go back to, you want the district court to make individualized findings. You've asked us to vacate and remand. Can we go back to that so I understand it? I quite didn't understand it in your brief, because I thought individualized findings had to do with the class action, but that question hasn't been certified here.
Right, but I think the merits. Our basic point is that a person does not have an Eighth Amendment defense or an Eighth Amendment claim unless he truly does not have some other place to reside. And so, by speaking of individualized, what we were saying is that it depends on whether that person has some other place, has a relative.
I accept all of that. I guess what I'm asking you is, and this is what I didn't understand from your brief, are you saying that there can't be a class certification of homeless people ever?
No.
That you have to have individuals? Or are you saying that the injunction is too broad if it doesn't provide for remedies that are somehow that the person has to prove a certain number of things before they're entitled to the injunction? I wasn't sure.
No, but the Eighth Amendment claim is a personal one, and this context depends on whether the person does have another place to sleep. So the person cannot benefit from the Eighth Amendment claim without an individualized, without that person showing, if it comes up in a affirmative injunctive action, without that person showing that he or she has no other place to stay.
Thank you, counsel. If there is the town next to Grants Pass, 10 minutes away, has just completed building a homeless shelter that has many vacant beds. Does that change the analysis here? We talked about the town wanting to ship people out of the town. Would it be, would there still be a right to sleep contrary to the ordinances in Grants Pass because you don't want to be taken 10 minutes away where there's a homeless shelter?
That goes to the question, I think, under the analysis of whether the beds are available. And I think if they're right across the town line, it would be appropriate to take into account that there's a homeless shelter there, even though it's not one in the city of Grants Pass. But often in a situation, the two towns might cooperate to have one homeless
Well, yeah, they might, but often next towns don't always cooperate. So what if it's 30 miles away? Is the shelter available in that case for your purposes? Or are you going to tell me it just depends on all the circumstances?
Well, I think it depends on
municipalities won't have that much.
I think it depends on the accessibility. I mean, one of the fundamental points here.
The accessibility is that when an officer comes up in Grants Pass and finds a homeless person and says it violates our ordinance, but I will give you a ride down the road, 30 miles, whatever it is, because there's a new homeless shelter there, and the person says, no, I don't want to do that. Can that person be given a citation?
I think probably not, but let me, if I could explain why. Obviously there are questions at the margin here, but I think one of the principal features here that shouldn't be overlooked is the city is seeking to banish or expel its own residents, its own citizens, people whose children can go to school in that location, who may pay taxes in that location. So if the 30-mile-away shelter requires the person to leave his community and to live at another place, that implicates that.
How far does that go? Let's say there are 5 cities all around Grants Pass, and they all have homeless shelters, and yet the person wants to stay. I've been a Grants Pass resident for a long time. I don't want to go to one of those shelters. Can that person be given a citation?
I think because of the concern I've mentioned, I think that would be a serious problem because...
You would say there would be a problem to give them a citation?
Yes, I think so, because you would be requiring, or the city's ordinance requires them to leave the city of Grants Pass. If the homeless shelter is right over the line, they can still be part of the community of Grants Pass.
No, but it's in another city. You keep fighting.
And that's why I think it's different. I'm not prepared to say that absolutely not, but I do think it's different because the city is implementing its policy of banishing people, its own residents.
Banishment is a strange word when you're talking about something 10 minutes away.
But again, the question is whether you could still realistically be part of the community where you grew up. The figures show it. In fact, JA 114, 115 here shows that most of the homeless people in Grants Pass are from Grants Pass.
Counsel, everyone's mentioned, not everybody, many people have mentioned this is a serious policy problem. And it's a policy problem because the solution, of course, is to build shelter, to provide shelter for those who are otherwise harmless. But municipalities have competing priorities. I mean, what if there are lead pipes in the water? Do you build the homeless shelter or do you take care of the lead pipes? What is isn't enough fire protection? Which one do you prioritize? Why would you think that these 9 people are the best people to judge and weigh those policy judgments?
We're not suggesting that. And we're not suggesting that the only solution is especially in the current circumstances, the only solution would be to build homeless shelters. As I mentioned, time, place, and manner restrictions, I think, are a very sensible way to go. And in fact, as I mentioned, Oregon state law requires that. In other words, a city adopts a provision that you can't you can't sleep on the sidewalks anywhere because that obstructs people seeking to move. You can't camp near a school. You can't camp downtown. You can't sleep downtown. You might be able to sleep in a park, and so a park, and that could be patrolled for drug use and whatnot. None of these other laws are inapplicable if there's a time, place, and manner restriction.
This is an old question, but eating is a basic human function as well that people have to do, just like sleeping. So if someone is hungry and no one is giving him food, can you prosecute him if he breaks into a store to get something to eat?
Absolutely. Breaking into a store is a common crime that not everybody engages in, unlike sleeping, which is what we have here.
But it's a necessity for the person who needs food.
It's not a necessity to break into a store. And with respect,
you're fighting the hypothetical. I'm saying this person needs food,
and the Eighth Amendment does not require that person be excused from doing it. I think there's a certain amount of common sense and practicality to this, and it's, I think, well understood that just like drug use is not something the Eighth Amendment excuses you from, either is eating. And the problem with eating is addressed at the local level, as the history in the poor law shows, is that the community takes care of its own residents, and it's common now as it was at the founding for churches and individuals and whatnot to offer their help to charity in the community, and that's what happens in Grants Pass. Various organizations feed the homeless people, and there are social services to help the homeless people. So this is consistent, except for the absolute ban on sleeping in the city. Otherwise, the community's response is what has been done down through history. It's the city's absolute ban that interrupts that continuity.
Justice Thomas. Justice Alito?
Could you explain how your rule would be carried out by police officers on a day-to-day basis? Let's say that there are 500 beds in a particular town, and let's say it's 3 o'clock in the afternoon, 4 o'clock in the afternoon on a winter day. What is an individual police officer supposed to do? The individual police officer would go around and count the number of people who are getting ready to sleep outside. I guess if that's 4 o'clock, you wouldn't get that. Let's say it's 6 o'clock. Count the number of people who are getting ready to sleep outside for the night, and then ask each one of them whether you've tried to find a bed at a shelter, whether that person would be willing to go to a shelter if a bed is available, without any conditions, or whether the bed would have to be available on the conditions that the individual wants, like I won't go to a shelter where they won't take my dog or something like that. Just explain how it would work on a daily basis.
Well, first of all, with respect to the individual encounter, I think the way this would work in the real world, I think it's important to understand what happens on the ground in these situations. I think in the circumstances you're talking about, I think what would happen is that the person encountering the homeless person would know whether there is a spot available. I don't think a homeless person would be required to check each day with each shelter if there are multiple shelters. And in larger cities, these initial encounters are not handled by law enforcement. They're typically handled by social services agencies who are in contact with people who are camping and know what their circumstances are, and they are able to say, we know that at such and such shelter there are beds available.
What if there's a question about whether there are indeed enough shelter beds available? Your rule wouldn't apply if there are enough beds available, right? If there are 500 shelter beds and there are only 200 people who are trying to sleep outside, then your rule wouldn't apply.
Right.
So you have to have a comparison of the number of beds available with the number of people who want to sleep outside.
Right, yes.
So that would be the threshold question.
Right. I just want to clarify one point about that. It's not simply a measure of the number of beds enforce the law at all. If you have individualized questioning and you know that there are vacancies available, even if not for everybody, but there is a vacancy for the person being interviewed, then yes, that person, if that person is offered and refuses, that person could be prosecuted or cited. So
what if the person says, I know there's a bed available at the Gospel Rescue Mission, but they won't take my dog?
Yeah, I don't think the inability to take your dog to the shelter is a sufficient reason. There are shelters in some larger cities that may well take pets, but
I know I could sleep in the home of a family member, but they really hate me and they're really nasty to me. I'm not. These are. I'm just wondering how this is going to be administered on a daily basis.
I think, with all respect, I think that example is if the family is going to accept him, but that's the question, whether there is a place to sleep. And I don't know that it would very often come down to that family hates me. On the other hand, if it's a woman who left domestic abuse, she couldn't be expected to go back to her home, or maybe her relative's home, or his relative's home, or something. So there's a lot of common sense. And again, the law enforcement, the first encounter that a police officer or somebody else has with a homeless person is very unlikely to be a situation in which the person would be issued a citation.
You mentioned just a couple of things that I wanted to follow up on. Does it matter whether the person grew up in the town or not? Suppose that they go to that's irrelevant. So they go up to some police officer or social services in San Diego goes up to somebody and says, where are you from? Oh, I'm from Fargo, but if I have to sleep outside, I sure would rather do it here than in Fargo. That doesn't matter.
No, and I think not because of any Eighth Amendment rule we're talking about, but under this court's decisions in Edwards and Signs, the Privileges and Immunities Clause, or the Commerce Clause, or the various right to travel provisions would prohibit attaching that sort of limitation to a newcomer. But I would, as I mentioned,
where I used to live in New Jersey, there are a lot of really small municipalities. I think over 500 municipalities in the state. I could go for a 20-minute walk in the evening and be in 3 or 4 different municipalities. So to get back to the Chief Justice's question, if there aren't enough beds available in West Caldwell, does it matter? Is it West Caldwell's out of luck, even though there are a lot of beds available in Caldwell, which is a couple less than a mile away?
Yeah, I think the way you're describing it, it might be fair to say that set of small and closely knit communities would be one community, and the person wouldn't basically be banished from where he lived or where he grew up by saying, if there's a shelter in this other location, then you could be expected to go there.
There's some tiny municipalities. What if a municipality doesn't have a park? So if somebody is going to sleep outside, the only place where that person can sleep is going to have to be on the street.
Right.
Does a time, place, or manner restriction work there?
It's certainly not on the street, and because of safety, traffic, et cetera. I mean, there are common sense accommodations, and I think even in the smallest town, there are probably locations where a person could sleep.
You're here to help.
Thank you.
I don't want to be repetitive. What are we vacating and remanding for? You interpolarized finding of what?
Well, the way that first of all, the class was defined simply on the basis of the aggregate numbers without an individualized determination as to whether, frankly, in our view, not a sufficient individualized determination as to the two named plaintiffs. And you identified several factors here. They both slept in their cars. Several of them were able, or both of them chose at sometimes to sleep at a Safeway parking lot or with a friend. The other slept at a truck stop out of town. It's not clear that neither of them ever actually camped in a park. In fact, the dissent below questioned whether one of those two people even had standing. So that there, even with respect to the named plaintiffs, there was not the sort of examination of their individual circumstances.
So you're talking about standing.
Well, standing, yes, and then there could be typicality or commonality problems there too if the two named plaintiffs slept in vehicles, which may present different problems than in the.
Well, we were told that sleeping and camping is out of the case because the court said
sleeping, yes, but sleeping in a vehicle counts as camping. But it's not the sort of camping that we've been talking about to some extent about sleeping on the ground with a blanket or a tent or something like that. And it's true, the question of tents are not in the case. And if the city wanted to allow tents, I suppose it could even require that they be taken down and put back up. There's a lot of flexibility that the city could have.
Well, I did want to ask you just about that. I mean, let's say I'm with you, Mr. Needler, on the fact that you can't prohibit being homeless. And because you can't prohibit being homeless, you can't prohibit sleeping outside if you are a genuinely homeless person. And let's say I'm with you that the fact that this ordinance says, well, but we're prohibiting using a blanket, that can't be right. You're not just get hypothermia and the constitutional problem will go away. But it does seem as though there are line drawing issues as you go up, right? It's a very cold night and somebody wants to make a fire. It's raining and somebody wants to put up a tarp. The city has said you can sleep in particular areas, but it turns out that those areas have a ton of crime. You could go on and on. And I'm not... how do you deal with questions like that? These are not like gotcha questions. This is like... how do you deal with questions like that? Where is the line where the city can say our legitimate municipal interests can come in and say, as to that, you can't do that?
And there's several examples that you have there with respect to tents and tarps, I guess you were saying. I think there's a difference between what you might need to realistically sleep outside if it's raining, snowing, or something like that, and what you might prefer to have as a structure for a long-term camping. As I mentioned, the city might say you can put up a tent if it's very cold, but you got to take it down in the morning. That's like being in some shelters say you can stay here overnight, but you have to leave during the day and you can come back. I mean, that might seem gratuitous to the city to do it. It might not want to do it. But we're not saying that the Eighth Amendment would prevent it from doing it, and especially, as you say, if there's no alternative and it's 20 20 degrees. And with respect to fires, there are really important issues on the other side of that question. And in an urban area, if you're creating fires, there may be hazards. In a park, there might be fireplaces.
How does the court make these judgments? Because these are tough judgments, and usually they're the kind of judgments that we think of as municipal officials make them. But you're saying, no, there's a certain level where it's out of their hands and it's in the court hands. And I guess I want to know what the principle is, where those questions go to the courts, and why that principle is the right principle.
I think there are two principles. One is that it's the municipality's determination, certainly in the first instance with a great deal of flexibility, how to address the question of homelessness, and a time, place, and manner, and the municipality should be able to choose the place, should be able to choose the attributes of that place, should be able to say we're not going to allow more than 20 people or something, to regulate it in that manner. And I think the principle, the Eighth Amendment principle, would be whether the city has effectively prevented sleeping outside because the protections needed from the elements are not available, and certainly in Grants Pass, I would think. But I think that's the touchstone. Are you basically, does it boil down to, or is the core principle of Robinson that you can't criminalize homelessness, which includes not being able to criminalize sleeping outside? If you can't sleep outside because of lack of protection from the elements, I think that's the principle a court would apply. But the Ninth Circuit in a number of cases has gone way beyond that, and we think that's really the source of the problems that have been identified in the briefs, and not the core principle of Robinson.
Thank you.
Justice Gorsuch.
Mr. Kneedler, I want to probe this a little bit further, because it does seem to me the status conduct distinction is very tricky. And I had thought that Robinson, after Powell, really was just limited to status. And now you're saying, well, there's some conduct that's effectively equated to status. But you're saying involuntary drug use, you can regulate that conduct. That doesn't qualify as status. You're saying compulsive alcohol use, you can regulate that conduct in public drunkenness, even if it's involuntary. That doesn't qualify as status, right?
Right.
You're saying you can regulate somebody who is hungry and has no other choice but to steal. You can regulate that conduct, even though it's a basic human necessity, and that doesn't come onto the status side of the line, right?
Yes.
Okay. But when it comes to homelessness, which is a terribly difficult problem, you're saying that's different, and because there are no beds available for them to go to in Grants Pass. What about someone who has a mental health problem that prohibits them, they cannot sleep in a shelter? Are they allowed to sleep outside or not? Is that status or conduct that's regulable?
I think that the question would be whether that shelter is available.
It's available.
Well, no, available to the individual.
It's available to the individual. It's just because of their mental health problem, they cannot do it.
I think there might be, that's the mental health
status
problem.
Or conduct.
Well, the mental health situation is itself a status.
Right, I know that.
Yes,
but it has this further knock-on effect on conduct. Is that regulable by the state or not?
I think that if the
all the alcohol, drug use,
right.
that they have problems too, but you're saying that conduct is regulable. How about with respect to this pervasive problem of persons with mental health problems?
I think in a particular situation, if the person would engage in violent conduct as a
don't mess with my hypothetical, counsel. I like my hypothetical. I know you don't. It's a hard one, and that's why I'm asking it. I'm just trying to understand the limits of your line.
I think it would depend on how serious the effect was.
It's a very serious effect. The mental health problem is serious, but there are beds available.
What I was trying to say is it would depend on how serious being required to go into that facility was on the person's mental. If it would make his mental health situation a lot worse, then that may not be something.
So that falls on the status.
Well, I guess you could put it that way, but I guess what I'm saying is
that's what I'm asking you. I really am just trying to figure out.
You could view that as
You're asking us to extend Robinson, and I'm asking how far.
Well, what I was going to say, you could think of it as status, but I think another way to think about it, and this is our point about an individualized determination, is that place realistically available to that person?
It is in the sense that the bed is available, but not because of their personal circumstances.
Right, and that's my point. It's available in a physical sense. It may be available to somebody else, but requiring an individualized determination might include whether that person could cope in that setting.
So that might be an Eighth Amendment violation.
Because it may not. Yes, because
it's an Eighth Amendment violation to require people to access available beds in the jurisdiction in which they live because of their mental health problems.
If going there would...
How about if they have a substance abuse problem and they can't use those substances in the shelter? Is that an Eighth Amendment?
That is not.
Why? Why?
If it's the shelter's rule, then they have no... They can't go there if they're addicted. That's not.
So that's an Eighth Amendment violation.
No, the Eighth Amendment violation is prohibiting sleeping outside because the only shelter that is available
is not really available to that person.
Won't take them. Yes, and that's an individualized determination.
Same thing with the alcoholic.
Yes.
Okay, so the alcoholic